I'm attorney Siobhan Olivero, and today I'm going to talk about the coronavirus and the courts. What to do now that the COVID-19 Florida Supreme Court orders have been entered, and how does it affect your court case? You know that facing a case in court can be stressful and overwhelming, and now we have the coronavirus for COVID-19 and stay-at-home orders that have been issued in many counties in Florida, as well as administrative orders in circuit courts and from the Florida Supreme Court. And in this video, I'm going to focus on the administrative order specifically from the Florida Supreme Court that was issued on April 6th of 2020, and talk about what it entails and what that means for your court case. So on April 6th, 2020, Chief Justice Kennedy of the Florida Supreme Court issued an administrative order that extended the measures, deadlines, timeframes, and some court closures until at least May 29th of 2020, or until a subsequent order of the court is issued. Now, the order addressed remote electronic court hearings, and in the order, the Supreme Court suspends any rules of court procedures or court orders that would normally prohibit the use of communication equipment for holding hearings by electronic means. So that means that courts are now allowed to conduct court hearings electronically, either by telephone or by some video application such as Zoom or Skype. And the Supreme Court has authorized the chief judge in each circuit court to establish procedures for holding those hearings remotely and electronically. However, some court hearings are completely suspended. Jury trials are completely suspended until May 29th of 2020. So if you had a jury trial scheduled at some point in March, April, or May, that case is going to get continued. In addition, grand jury proceedings are suspended until after May 29th of 2020. So if you have an attorney, contact your attorney for guidance on how your trial is going to be reset. However, in most cases right now, the courts are removing the cases from the trial calendar, and they're scheduling them for status conferences or pretrial conferences. And those are either being scheduled remotely and a date in May or June, and they'll be held remotely through May 29th, or they're rescheduling the status for a date in June or July. The cases will then be set for another trial date at that pretrial conference or status hearing that's scheduled in the case. The court listed essential and critical trial court proceedings that are still being held. So essential court proceedings have been listed and determined by the Supreme Court, and some of those types of hearings are first appearances for those who have been arrested, hearings to modify or set bonds for person in custody, hearings on petitions for injunctions against violence, hearings for temporary guardianship, and hearings to determine if someone should be involuntarily committed under a Baker Act or Marchman Act. Critical proceedings that the court has listed are those that are relevant to the state of emergency for public health, which are for violations of a quarantine order, violations of orders to limit travel, violations of orders to close public or private buildings, and in the enforcement of curfew orders. The court can hear these essential and critical court hearings in person as necessary. However, they have to employ methods feasible to minimize the risk of exposure to COVID-19 to all persons involved in the proceedings. As to anything non-essential or non-critical court proceedings, so anything not listed in the court's order as a critical or essential proceeding, the Supreme Court has directed the chief judge to review the cases and the technology available and to issue directives to the judges in their circuits to either reschedule, postpone, or cancel all non-essential and non-critical court hearings. However, if the hearings can be done effectively and done remotely by telephonic or video means without in-person appearances, they can still go forward remotely. No court proceedings other than essential or critical proceedings are to be conducted in person. If they cannot be conducted remotely, then they must be rescheduled if they are not essential or critical hearings. The suspension of time periods in criminal cases are affected by the Florida Supreme Court's order. Specifically, what I want to talk about is the speedy trial time period. So all time periods that are in the calculation of speedy trial are suspended through close of business on Monday, June 1st, 2020. So this means that any time periods from March 13th of 2020, when the Florida Supreme Court entered their initial order suspending timeframes, until June 1st are suspended when we're calculating speedy trial. Now that's a total of 81 days. So those days have to be determined and calculated to your individual case if you have a speedy trial issue in your case. This can be confusing on how to determine a new speedy trial date after June 1st. You should check with your attorney on calculating the new date. If you don't have an attorney and you'd like help calculating that new date, we are here and able to assist you with that. Next, the Supreme Court addressed defendants who are arrested on a warrant from another jurisdiction. So this happens when, for instance, someone has a warrant out of Hillsborough County, but they're arrested on that warrant out of Polk County or Pasco County or some other county. And the Supreme Court has encouraged the circuit courts to facilitate communications between themselves when someone's been arrested in one circuit for a warrant and they have a warrant out of another circuit. Normally what happens is when someone is arrested outside of the county of origin for the warrant, the arresting circuit cannot modify the conditions of release or bond, and they must transfer the person to the originating circuit for those determinations. However, with the COVID-19 crisis, the Florida Supreme Court has advised the circuits to work together in active communication. The chief judge in the arresting circuit is authorized to address release conditions and bonds for a person arrested on a warrant outside of their circuit, as long as the judge obtains the relevant information necessary to make a proper decision regarding bond and conditions of release. And they get that information from the issuing judge or from the state attorney's office. And any action taken by the holding court in granting bond or pretrial release must immediately be reported to the home court, the one that issued the warrant. The Supreme Court has also authorized the judges in the arresting circuit to accept pleas for persons arrested on the out-of-county charges, as long as both the defendant and the prosecutor agree to the plea. However, if the person remains detained, their due process rights have to be protected, and they have to ensure the immediate transfer of the person to the issuing court. If the person cannot immediately be transferred, then the holding court must designate a judge to handle any emergency matters that may come up while the person remains in their custody. The next thing the court addresses is the administration of oaths. And this is specifically with witnesses in hearings. And the Supreme Court has authorized that any notary or person qualified to administer an oath can administer that oath remotely by audio and video equipment to swear in the witness. The person giving the oath must both see and hear the witness, so by audio and video, and they must be able to positively identify the witness. And the witness must be in Florida. However, if the witness is not in Florida and the witness then has to consent to being placed under oath by the audio and video communication by a person qualified to give the oath in Florida. Next, the court addressed writs of possession. This specifically has to do with eviction matters. And all writs of possession are suspended currently until May 29th of 2020. So this means that although eviction procedures can still be filed in court against someone, no writs of possession, meaning the orders that are issued that require the person to be removed from the property, are going to be enforced and served until at least May 29th of 2020. The next thing the court addressed is certain forms in family law matters. Certain family law forms require that they be signed in front of a deputy clerk or a notary, and those requirements currently are suspended until May 29th of 2020, as long as the person who is filing the form includes a statement that, under the penalties of perjury, they declare they've read the document and the facts stated in it are true. And as long as that statement is included, then the requirement to be signed in front of a clerk or a notary is suspended, and you just have to have that statement and your signature. This does not apply, however, for forms that we call marital settlement agreements and any other type of form that transfers the ownership of property. Those documents still must be signed before a notary. And finally, the Florida Supreme Court addressed visitation for children who are under the supervision of the Department of Children and Families, or DCF. This specifically only applies to children that are in the care and supervision of DCF. It does not apply, for instance, to regular type of family law cases dealing with divorce and child custody issues. So for children that are in the supervision of DCF, requirements for in-person visitation are suspended. And that applies to parent and child visitation, sibling visitation, visitation between the child and other family members, and non-relatives. However, if everyone and the caregiver, all parties and the caregiver agree that visitation can still take place in person in a manner that does not pose a health threat to anyone, then the visitation can occur. So how do you get visitation? If your child is in the custody and supervision of DCF, visitation during this time is to occur by video as the preferred method. If video is not available as an option, then telephonic visitation is to occur during this time. If all parties cannot agree that in-person visitation can go forward in a way that doesn't pose a health threat to everyone, then a party can file a motion to reinstate in-person visitation, and the court must hear those, and it must be heard on a case-by-case basis. The court must determine that the in-person visitation will not jeopardize the health, safety, or well-being of all children, all adults, all caregivers, or anyone else who will be affected by an in-person visitation. If you need help navigating your case in court during this time, we are here to help you. If you have any questions on how your case is affected during these orders and any time frames or things that you need to help have calculated, we are here, and you can contact us at 813-654-5777 or at info@oliverolaw.com. We hope you all are staying safe and healthy, and we are here for anything you need. Thanks, and we'll talk to you soon.